Herzlich willkommen zum Podcast Fokus Strafrecht und zu einer weiteren Folge in unserer Staffel zum Thema Digitalisierung und Strafrecht. Wie immer mit Nadine Zurkinden, Assistenzprofessorin für Straf- und Strafprozessrecht an der Universität Zürich. Hoi Nadine.
Hallo Claude, neben mir sitzt Claude Erik Bertschinger. Er ist promovierter Jurist und Rechtsanwalt und hauptberuflich Dozent für Straf- und Strafprozessrecht an der ZHAW in Zürich.
Um was geht's denn heute eigentlich und wen hast du eingeladen?
Ich habe heute eine Professorin aus Belgien eingeladen, und zwar Vanessa Franzen von der Universität Liège. Es geht heute um das Thema AI in and around the courtroom. Wir haben die heutige Folge ausnahmsweise auf Englisch aufgezeichnet. Und ich habe Vanessa Franzen eingeladen, weil sie schon seit einigen Jahren zu verschiedenen Themen im Bereich Digitalisierung und Strafrecht forscht.
Das Interview mit Professor Franzen haben wir am 30.10.2024 anlässlich ihres Besuches an der Universität Zürich aufnehmen können. Sie hat uns interessante Einblicke in verschiedene Anwendungsbereiche von AI-Tools in der Justiz geboten. Zum Beispiel zu Vorhersagetools, die Urteilswahrscheinlichkeiten oder Rückfallrisiken beurteilen können. Sie hat uns auch internationale Zusammenhänge erläutert, etwa betreffend den AI-Act der EU. Ich muss sagen, ich war vorher dahingehend kaum auf dem Laufenden und ich habe immer wieder gestaunt, was für Tools bereits heute im Einsatz sind.
Fokus Strafrecht. Der Strafrechtspodcast der Universität Zürich. Für Profis und solche, die es werden wollen. Mit ihren Hosts Prof. Dr. Nadine Zurkinden und Dr. Claude Erik Bertschinger.
Today's episode is all about AI in the courtroom, and we are very happy to have a wonderful guest with us, Professor Dr. Vanessa Franzen. She is a professor of law at the University of Liège in Belgium and a senior researcher at KU Leuven Institute of Criminal Law. She specializes in EU criminal law, economic and financial criminal law, cybercrime, and the intersection between criminal and quasi-criminal enforcement in Europe. Her recent work focuses on the impact of new technologies, including AI, on criminal law. That, at least, I have learned from ChatGPT. Vanessa, are you happy with that introduction?
Hello, Claude. Hello, Nadine. Yes, I think that could work. It's fairly accurate. Thank you.
So, as a former courtroom clerk, I must ask, what are your experiences in a courtroom, and how could AI tools help us in the future to alter these experiences that we all have as attorneys or judges or law professionals?
Well, I have been at the bar for some time, but being a full-time academic, my experience at the bar is not so extensive. From what I have seen as a practicing lawyer, there's a lot of chain work in some sort of cases, like in traffic law, where a usual case takes 4 or 5 minutes before a court. And then there's, of course, much more complex cases. So considering the variety of cases there might be different uses of AI that we could consider. Personally, I haven't seen any AI being used in AI or in courts so far. But of course, evidence that is brought to the courts these days may already be based on data analysis by AI tools, for instance, especially in bigger cases where there has been an analysis of large data sets where the police or the public prosecutor or both have applied AI tools to work their way through these large data sets. An interesting question then that relates to that is whether the courts are even aware of the fact that AI tools have been used earlier on in the gathering or analysis of data that could or has become evidence.
I was just thinking that because to my experience, I've never been aware that these tools exist, at least not in Switzerland or in Swiss courts. I've never noticed that there might have been AI tools already applied to some of the evidence.
I think it's mainly the police that uses them, has been using them for a long time already, whether it's as predictive policing tools to know whether at a certain moment in time there's a higher risk of crime being committed so that they can focus their attention more on specific areas in a city, for instance. So those tools have been around for, I would say, 1 or 2 decades already, and there's quite some literature on this. Debate on whether these tools are very accurate or not, but that's very often predictive. So before a crime has been committed, and then it's rather, I would say, in the analysis of data that is gathered that those tools are being used. But I'm even not aware, or sure rather, I'm not sure whether the public prosecutor is well aware of the fact that the police is using AI tools to analyze data. So the information about those tools doesn't necessarily go down the stream until you end up in court.
What is AI?
Maybe it would be a good idea to define what does AI mean.
That's a very good question indeed. So AI tools is actually, one could say it's a kind of software, it's a computer system, but you have different types, and some of them are quite easy to understand. Those are knowledge-based, and actually it's the human being who sees the patterns or who knows the rules and programs those rules into a software. And then that computer system can take over tasks that otherwise the human being would be doing, but the computer system will not learn by itself. Whereas other systems that are data-based are much more complex. You feed data into the system, and the system will be analyzing that data based on criteria, which of course are programmed by the human being. And either the human being will define in which order those criteria are applied in a decision-making tree, but it could also be the system who is looking itself for certain patterns in raw data and then comes up with certain patterns or solutions. So there's a lot of variety in those database systems. The AI system will be learning by itself, based always on data that is fed into the system. So that's already one of the weaknesses, because the quality of the data will also be highly determining what is coming out of the AI system's analysis. And it's always past data. So it's data that has been collected at a certain point in time that is used to train the machine. And the more deep the learning is, then we're talking about machine learning and deep learning, the less understandable the process of the AI system will be. So it makes those systems more opaque. They often refer to black boxes, because you know what you put into the system and you ask the system to look for certain patterns and it will come up with those patterns, but you don't know how it has arrived at that pattern. For instance, you could ask the machine based on a whole data set to determine whether a person has a high risk score to repeat offending. So you feed data into the system, and then it will be based on a number of criteria that are predetermined, but perhaps also new ones. It will come up with risk scores between 0 and 10, but how it has come up with those risk scores is not necessarily so obvious or transparent to the ones using the risk scores down the road.
So they have no way really to verify the results, so to speak.
They will not be able to verify everything. So you would have to have access to how the system works, what data it has been trained with, tested with, and that obviously is, of course, covered by trade secrets.
And I don't mean to offend any police officers, but I presume they're not the ones who are programming the AI.
Well, that depends. There are public authorities who develop their own tools around Europe, and I'm sure also in the United States. But there are obviously also a lot of private companies who offer those services, and then either the public authorities use them right away as they are offered, but they might also amend or change the system to their taste, and that will be important from a regulatory perspective to know who is a provider of the system or who is a deployer of the system, which comes with different obligations.
What about official secrecy in that relation? If private companies are prosecuting authorities with such systems?
Well, that's one of the questions. Once you provide the AI tool, there might, of course, be questions if the data comes back to the provider of the AI system, but I think it really depends on the AI tool, the conditions under which it has been licensed. So, for instance, with autonomous vehicles, we know that there are certain companies who, the data that is collected by all their vehicles around the world allows them to improve their systems. And that is also true with a number of other devices we use, like ChatGPT, which you have kindly used to introduce me, which are open source. And if I'm not mistaken, if you use it, the free version of it, it gives you a warning that you shouldn't use personal data, because then the data will indeed be used to improve the system. But I'm not so sure that this is the case with sensitive data. With ongoing criminal proceedings, that would be very tricky, I think. There are, for instance, requirements on, cloud computing software that is used by public authorities. There have to be guarantees about where the data is stored. Public authorities always ask whether other public authorities of foreign nations could have access to their data. So I guess there should be some kind of protection in those contracts. But I'm not aware, I haven't had access, so I'm a bit in the dark about the right answer to this. But I cannot imagine that ongoing criminal proceedings would be able to feed the system in real time when there's a criminal proceeding. Predictive policing, that might be something else, because then you're before a criminal proceeding.
Predictive AI tools.
You've already talked a little bit about this predictive policing. I recall having watched a movie, an older one. It's called Minority Report, if I recall correctly.
Dr. B explains.
My next question refers to Steven Spielberg's 2002 movie Minority Report. Set in the future, it follows John, played by Tom Cruise, who works for a special police unit called Pre-Crime. The unit has 3 heavily sedated virgins who float upside down in a pool and have visions of the future. These visions can be read using brainwave meters and visualized with modern technology, allowing the police to identify future crimes and arrest the predators before they commit those crimes. Predictive policing. Is that something, as we see in this movie? I mean, there's obviously not 3 ladies swimming in a pool foretelling the future, I presume, but how does it work?
Well, it's a long time since I saw that movie, so I'm not
Me too,
completely recollecting everything. I forgot the ladies in the pools. But how do these systems work? There's a number of systems on the market by bigger companies like Palantir, for instance, and there's a famous one that is called CAS, which are used by police services around the world, which are trained with past data based on a number of criteria, and that help the police to predict in what areas there will be crime. Now, this doesn't focus on individuals. It will rather say, considering, for instance, the income level in a certain neighborhood, the low employment rate, many single-parent families, past facts that have taken place, offenses that having. It's a neighborhood where there's a lot of drug dealing, for instance, and addicts, drug addicts. Based on all that kind of data, it will provide a risk score. What is the likelihood of having new offenses being committed in a certain area? So it's not focusing on an individual. It could, but then again, it's a risk score that is based on past group data. So what did male in their 20s from Caucasian background, being out of employment and so on and so forth, with a low education level, what is their risk score? So you take group data and then you apply that to a certain specific individual. But that's then predictive analysis for a specific human being, which is very tricky under new EU legislation. And you have predicting policing, which is broader, which doesn't focus on individuals, but on areas.
Are there also AI tools that are used in other contexts, for example, in a decision-making process for sentencing?
Using them for sentencing purposes has been done in a very famous case, the Loomis case in the United States, in the state of Wisconsin, where a tool that was developed for providing a risk score for future offending, but only with respect to parole decisions, that is, post-sentencing. So someone has been convicted to, let's say, 5 years of imprisonment. Should he be entitled to apply for parole, meaning that he can be released after 3 years, depending on the rules that apply? That's the kind of tool that was used, but it was then used in a sentencing situation. How high should the imprisonment be? And should it be imprisonment without the possibility later on to be granted parole, but a decision, a sentencing decision by the court? Whereas parole decisions are usually taken after the sentencing has been done and, in a later stage.
Isn't it problematic to use a tool that was developed for a different purpose in that context?
That may be highly problematical, because then you could indeed raise the question, is this a violation of a fair trial, which includes presumption of innocence? Because the judge will inevitably be guided to some extent by the risk score that is provided. That's tricky, because then you can question whether it's the tool that has determined the sentencing or whether the judge also looks really into the facts of the case and the person as an individual sitting in front of him or her.
Or does he just rely on a tool of which he maybe even don't know the data sets that are in there, and he cannot really see whether or not the tool is coming to the right conclusion?
He will most likely not know.
Exactly.
He will not know, indeed. And in that particular Loomis case, it was asked to have more insight into the tool, the AI tool that was used to provide a risk score. And the company was, of course, defending itself by saying, this is my trade secret. So there was not much information. There was some information given to the judge, but very limited.
And what was the outcome of that case?
Well, in that case, he was sentenced quite heavily because of, I'm not able to say, because
we don't know either.
We don't know how much the court was influenced in its decision-making on the sentencing by the AI tool. But Mr. Loomis, the defendant, got a quite high risk score by the system, and so he was sentenced quite heavily.
Did he challenge this court decision?
He challenged the court decision, arguing that his due process rights had been violated, which is similar to what we know in Europe as fair trial rights. And so he went to the Supreme Court in Wisconsin, arguing that he wasn't able to defend himself, he didn't have access to the system. Eventually, the court decided that there was no violation of the due process rights, but there was one justice on the court who, in a separate opinion, argued that there should be a notice to the court saying, the data that's used is group data that has been collected all over the United States, so not necessarily specific to the state of Wisconsin. Imagine that a tool would be used that has been developed for the entire Europe and then is used in Switzerland, but Switzerland has different rules that apply and a different population than, for instance, Germany or France, which are neighboring countries and just around the corner.
Dr. B explains.
So Vanessa talks about a judge who issues a separate opinion. Contrary to Switzerland, there are some jurisdictions which allow individual judges, who are part of a judicial body that has to come up with a majority ruling, to put their own legal opinion in writing as well, thus making it apparent for readers that not all judges of the judicial body were of the same legal opinion.
So Justice Abraham insisted on informing the court about the data, the limits also of the system, what is the accuracy of the tool, and noticed that this was actually a tool that should be used only in post-sentencing decisions. So a number of guarantees that should be provided according to this justice, but it didn't influence the outcome. The outcome was that there was no violation of his due process rights, and so there was no change in his sentencing decision, which remained the same.
So that seems to be quite a disadvantage of an AI system. Are there also some advantages?
I think there are definitely advantages. Some of them have been put out by a number of states already. Most courts in many systems are overburdened. So states around the world are looking for solutions to discharge courts, to alleviate their work. And there are a few systems that are already experimenting or even actively using such systems, like China has been using a smart court for a number of years now. And allegedly, according to the data that I can find on the internet that is publicly accessible, to the extent that it is correct, says that they have been able to save billions of US dollars by using this system, because it takes away, I think it was up to 1/3 of the workload of judges, which is impressive. I mean, I would have to check that data again, but it's an impressive reduction of workload thanks to the system.
How does that work exactly, the systems? Do you know?
That system has access to all kinds of databases, all public databases, from what I can tell. So also the famous or infamous social scoring system in China, all databases enhanced or controlled by public or government authorities, and makes a cross-analysis of that data to propose a decision to the court. And what is very particular is that if the judge, or if it's a panel of judges, the court, if it doesn't follow the proposed decision, the judge will have to explain why he or she is not following the solution that is offered by the system, which is the world upside down.
So there's a high incentive for the judge to just follow.
To follow, indeed, yeah.
Professor Z explains.
We now move to the European Union. In the European Union, there is legal framework that has to be taken into account when it comes to AI in and around the courtroom. In particular, fundamental rights, the General Data Protection Regulation, the Law Enforcement Directive, and the AI Act.
The human in the loop.
So you mentioned the world being upside down in China. What are the rules in Europe for the use of such tools?
In Europe, there are various guarantees in place, whether it's under personal data protection law or whether it's now with the new AI Act, where it's explicitly written down as a guarantee that decision-making involves a human being. And in the AI Act, there's a lot of insistence also on that this human in the loop should understand the system that he or she is using.
Maybe we have to quickly explain the term human in the loop.
The human in the loop means that the machine cannot provide a solution or a decision by itself. At some point, a human being should intervene or should be able to intervene, even if he or she doesn't intervene, but should have a possibility to intervene.
Now, the Chinese government could also argue they have the human in the loop as well, right, with the sentencing in their AI court. Only that the human doesn't really know whatever the machine came up with.
True. And that's where the AI Act, adopted by the EU legislature, comes in, which provides a lot of guarantees and, qualifies what the human in the loop means. It means that the human beings using the tools should be informed of the accuracy, for instance, of the tool, of the data that it has been trained and tested with. They should be able to know what the purposes initially of that tool were, and they should, be aware of the fact that they are using an AI tool, what its limits are, what it can and not can do.
And who has to inform?
The provider will have to inform the deployer of what the system is capable of doing. And the deployer should make sure that when the system is used, that it is used for the purposes that it was designed for, and that the user of that system, a police officer, for instance, knows what the limits and the advantages of the systems are. So it qualifies this human being, which in my view is a very good step forward, because from what I've heard is that public authorities, police authorities, judicial authorities don't always know so much about the tool that they are using, what it can or not, whether it's accurate or not, whether they should be mindful of the results that come out of the machine when using them. And this is really written down in the AI Act as guarantees, which is a major step forward, I would say.
Mm-hmm. Is there a but?
But you have to take a look also at the scope of application of the AI Act. For instance, it doesn't necessarily apply to courts because it applies to providers of AI systems and deployers. Deployers could be law enforcement authorities, but law enforcement authorities are defined as public authorities that are detecting, preventing, investigating, or prosecuting criminal offenses. Mm-hmm. Judges don't do any of this.
So, Vanessa, you've mentioned that the EU AI Act is providing guarantees. Are they provided for all systems?
You have high-risk systems that come along with a number of guarantees, quite substantial and good ones, I would say. And then you have more general use AI systems that come with limited guarantees unless they entail a systemic risk. And then you have certain AI that includes, for instance, generative AI, which is ChatGPT, for instance, that you use to generate content, a text. You ask a question and it generates content. Or you ask an AI system to generate an image that can be easily used, often for free. Well, those AI systems come along with a number of guarantees too, but with major exceptions for law enforcement authorities.
What kind of limitations and exceptions?
So, for instance, if the police would use a fake picture during a police interview, submit it to the suspect and say, look, this picture has been taken by a camera at that place at that time, and you are visible on this picture with one of the other suspects. What do you have to say to this? But the picture is fake. Well, in all other circumstances, the deployer of the system should say, well, be aware that this is a picture generated by an AI tool and that it's fake. But there's an exception for law enforcement purposes. So it doesn't seem to apply.
They are actually allowed to do that.
Under the AI Act, there's an exception. Then there's, of course, the question, isn't this a violation of the fair trial right?
Exactly. In our Swiss procedural code, I would say that it's prohibited to use such a tool.
Yeah, me
Just
too.
for our listeners who are now worried. Sorry, I interrupted you.
No, but the broader guarantees, of course, still remain in place. The AI Act doesn't affect them. It just says that guarantees it provides to generative AI tools do not apply to law enforcement, unless it's a high-risk AI system. For instance, polygraphs or similar systems, it says. So a lie detector. Yeah.
Also prohibited in Switzerland. Just
thankfully,
not prohibited in my own legal system, but usable with certain guarantees. Regulated since a couple of years, but it cannot be used as a sole basis to convict someone. So you need other evidence to corroborate the findings of the polygraph. But this is a high-risk system according to the AI Annex 3.
And why is it considered to be a high-risk system?
That's a good question.
Did they just come up with some examples, or?
It's not so clear. It's not such a clear definition. There's a number of contra criteria, you could say, that an AI risk that only performs, for instance, a narrow procedural task or only improves the result of a previously completed human activity, or that is intended to detect decision-making patterns in prior decisions. So there are a number of counter criteria. But to really understand what these high-risk systems are, we will have to wait until February 2026, because the European Commission will come up with a list of case uses of systems, AI systems, that should be considered as high risk.
So polygraph is one of the
Polygraph
examples?
is one. Another example that is also in the famous Annex 3 is AI systems used to evaluate the reliability of evidence in the course of the investigation or the prosecution of criminal offenses. So this is interesting because we could think of, for instance, AI systems that are used to check whether images, sounds are real.
Or deep fakes.
Or fakes, indeed. So that's a tool that you could, where you could envision that it's used not necessarily by courts, although it could. Imagine that a judge in the file finds images, sound,
Videos.
and wants to know whether this is reliable, even if the prosecution brought that evidence. But the defendant says, well, this is fake. An expert could be brought in. But the court, if it has the tools, could also use itself such AI system. Only the court, when using it, would not be directly covered by the AI Act. So those are two that are very clear, because defined by the AI Act as high-risk AI systems, which come along with a whole set of guarantees, like the human in the loop.
Prediction and human rights.
So, Vanessa, we've talked about all those AI tools. Are you aware of any tools in development here in Europe with regards to case law, for example?
Yeah, there's indeed a research that goes back a couple of years, and that has analyzed the case law of the European Court of Human Rights, who looks after fundamental rights of our fundamental rights of all of us. And in that research, an analysis was made of some 600 cases, focusing on 3 articles of the European Convention on Human Rights: Article 3 on the prohibition against torture, Article 6 on the fair trial right, and Article 8 on the right to private life, to respect for your private life. And so based on an analysis of 600 cases, the research came forward with a prediction tool on how the European Court of Human Rights could rule in future cases regarding the same articles. That's interesting, because then for people who want to bring their case to the European Court of Human Rights because they feel like their own judicial authorities, courts, have violated their fundamental rights, they could, based on such tool, make a prediction on what their success rate will be. Is it worthwhile going to the European Court in Strasbourg to bring my case?
Are there any limitations?
There's no distinction made with regard to Article 6, whether that relates to criminal proceedings or to civil proceedings or to both. It's only 3 articles. And of course, it's based on past decision making. So whatever developments, evolutions there are in society, which a human judge can take into account, this will not be able to be predicted by an AI system. And there's a number of such evolutions with regard to terrorist attacks, for instance. It's well known that the European Court of Human Rights has become a bit more open to certain tools used by member state authorities to predict and to be able to prevent terrorist attacks. With regard to mass surveillance, the European Court of Human Rights has become a bit more flexible, at least. So there's developments in society where the court replies to concerns of states and citizens. The AI system will not be able to give a success rate on how, on a new cutting-edge case, the court will rule.
Are there AI tools that are developed at the domestic level? And what risks might be coming with them?
For instance, in my own legal system, Belgium, we are only creating a case law database, because until just a year ago, there was no public databases with all case law. And the law that provides for this database explicitly says that there's a possibility to develop AI tools to help judges. What kind of AI tools is not provided by the law, but we could imagine that based on certain data, either public authorities or private companies asked by the authorities could develop AI tools to analyze a huge amount of case law, to give the judge an indication on how other judges and courts have ruled on similar cases in the past. This is interesting because it helps him or her to prepare his own decision-making. It may also bring more consistency in decision-making, which is, I think, positive. But of course, it will also narrow down and will bring typical cases to the court and perhaps may limit the open mind of a judge when a new case is brought to him, because he will think, well, in similar cases, according to the AI analysis, my colleagues in such and such districts have ruled in that sense. And will the court then still be as open and sensitive to distinctive elements in the case that is brought to him?
But is there even a need to come up with your domestic AI tool? Or, I mean, what would be the risk if you didn't?
Imagine that courts would be using ChatGPT. How much will what the system will propose to them as a good reasoning, how much will it be fitting the actual case at hand? And are we sure that the AI tool will not come up with fictitious cases, as we already know it has done in another case in the United States, where lawyers used for their court briefs ChatGPT, and then there appeared to be a number of case references that were fake, that the system has simply imagined. But those are needs of courts because they have such a high case load that they are looking for assistance. Whether it's assistance in helping them to build reasoning, I'm not sure the current systems will be also fit, because they're based on natural language processing, becoming more and more refined, of course, but based on a statistical analysis of what words are likely to be found in a similar context, and based on everything that is in the data that it's trained with, of course. So that might narrow down the openness of decision-making and the possibility for case law also to adjust to new phenomena.
And are there any further issues that come with the use of such tools?
Now, there's obviously a lot of issues with fundamental rights when it comes to a fair trial. For instance, you have a right to access to a court, which is independent and impartial. If the court is helped by an AI system to come up with a decision, how
independent is it?
How independent is it? Well, independency is, of course, with regard to the executive branch. But how autonomous is the decision of the court, and how much has the court really taken into account the individual facts and elements of the case in making its decision? That is one of the fundamental guarantees under pressure. Another one is related to the fair trial, and that's the right of defense. Shouldn't the defense be informed of the fact that AI tools have been used by the police to gather or to analyze data, and to which data sets should the defendant have access? Should they have access to the entire data set with, the raw material that is unanalyzed? Is this even useful? Should they have access to the second data set where a first filtering already took place, or only to the data that eventually end up in the case file? And those are questions that are gradually coming up to courts. How much possibility does the defense have to challenge the outcome of that system?
So the aforementioned access to the data sets used by the AI might be important to ensure the procedural concept of equality of arms amongst the prosecution and the defense. Are you aware of attempts of national prosecutors to ensure these fundamental procedural rights?
A good colleague of mine in the Netherlands, Professor Galic, she has worked a lot on these subjects. And she has presented also on an AI tool used by the public prosecutor and mainly police in the Netherlands, which is called Hansken, and which is used in big cases like EncroChat and SkyCC on big drug trafficking networks, and where the police are trying to create more transparency about the tool that they use. And they're also giving access to the tool to the defense so that they can come in and use the AI tool to see whether if they ask the AI tool to make a certain analysis, they will come to the same results.
Conclusion.
Now, to wrap this episode up, so in, say, 15 years, 20 years, maybe, probably I'm overestimating the amount of time it's going to take, I will have a client who has been arrested using predictive AI to find him even. And then he's prosecuted, he's interrogated, I get some evidence, I can look into the files for him. Then I will also ask to get information or data sets from the prosecutor's office or from the police. I will probably have my own AI tool to try and analyze said data to check out whether or not this is true or fake, the pictures, the audio are correct or are not deep fakes or anything similar. Then I will go log onto the court's website to see how probable it is to ask for X, Y, or Z for my client, because the court's website the AI will already provide me and the prosecutor with a potential verdict according to the data sets that are there. The court is using a similar tool to maybe come to a conclusion. And then there will be a sentencing and eventually maybe also a board that is talking about the probation of my client later down the road if he gets convicted and maybe put in jail. And then they will decide upon their data sets as well whether or not this client is eligible for parole. Is that the future as you imagine it, or as I have to imagine it, more or less? Is that the quintessential story of today?
I think it goes into that direction. Whether you will have access to the tools that are used by the court, public access, I'm not so sure. But it goes indeed a bit more in that direction, I think, which proves the necessity to have sufficient safeguards in place to make sure that it doesn't become a highly unpredictable AI game. So, Claude, in your future perspective on how criminal proceedings will be organized in the future, it may also be that AI tools are used by the public prosecution, for instance, to make a prediction about the likelihood of getting a prediction in court, and that the public prosecutor will say to the defense, look, if we take the case to court, there will be a 90 or 95% chance that you are convicted. So it's better for everyone that we close a deal, an out-of-court settlement, or a plea agreement that will go to court and will have to be approved by court, which may shorten proceedings. Or it may be used by the defense lawyer explaining to his client that if the case would be taken to court, there's a likelihood of X% of being convicted, or on the contrary, that he does stand a good chance to win his case, and so that it's worth the effort to take the case to court and not to close a deal or not to accept the fact that he or she will be convicted. So AI tools will give more information on the likelihood of success, which could be useful.
So if you have a not so experienced attorney, for example, who doesn't know the court that well, he or she could have a tool that helped her to realize whether or not she really had a chance.
That could indeed be the case, because now it's up to the experience of your lawyer, of the defense counsel, who will have a number of years of experience, already know the judges sitting on the court and know that they're sensitive to this or that issue and that they're likely to rule more severely in such case than in another case. But as a citizen, you rely on the experience that your lawyer has. In the future, you will depend on whether your lawyer has, access to an AI system.
So you're already reliant on the data set, but just this time the data set is stored in your lawyer and not in an AI tool.
Absolutely. It's limited to one lawyer and his colleagues in the same law firm. And the highest courts are asking for more evidence-based material. And technologies can provide for such data, but they can also measure anything and everything. So we should always be mindful of keeping the human in the loop, but a human who is well trained. Mm-hmm. And so if in 15 years you will have a defendant, I think you, but all of us, all lawyers, should be much more trained, perhaps have a minor in computer science, all of us, to be able to understand what the machines can do and what they cannot do, because they stay machines and they have their own way of developing output, which is not the same as how humans develop output. But there is a number of positive elements to AI, which we should use intelligently.
That's a beautiful final sentence, I think.
Absolutely. Thank you very much. It was very interesting.
Thank you for having me.
Thank you for being here. It was our great pleasure to have you. Thank you so much, Vanessa.
Strafrechtsfokus.
Das war das Gespräch mit Vanessa Franzen.
Ja, also es war sehr spannend. Ich fand viele Punkte, die sie angesprochen hat, interessant. Nadine, was sind denn deine Takeaways?
Ja, ich muss sagen, das Gespräch war wirklich sehr interessant. Ich bin ein bisschen nachhaltig schockiert über ihre Aussagen zu den Deepfake-Fotografien, die man allenfalls in gewissen Jurisdiktionen in der EU bei einer Einvernahme den Beschuldigten vorlegen kann, ohne denen zu sagen, dass das ein Deepfake-Foto ist, um sie quasi mit einer List zu irgendwelchen Aussagen zu bewegen. Etwas, das in der Schweiz auf keinen Fall möglich wäre.
Ja, wahrscheinlich ja auch in vielen EU-Jurisdiktionen nicht, aufgrund des nationalen Prozessrechts, nehme ich jetzt mal an. Aber der EU AI Act sieht das nicht vor.
Ja, und anscheinend auch nicht zu den Lügendetektoren, die dann je nach nationalem Recht auch erlaubt sein können in Strafverfahren, wie das ja in Belgien anscheinend der Fall ist, unter gewissen Bedingungen, die dann erfüllt werden müssen.
Vielleicht sollten wir noch ganz kurz erklären, warum wir als Profis so schockiert sind vom Einsatz von Lügendetektoren-Tests.
Ja, das ist etwas, was in der Schweizer Strafprozessordnung verboten ist. Und zwar steht in Artikel 140 Absatz 1 der StPO: Zwangsmittel, Gewaltanwendungen, Drohungen, Versprechungen, Täuschungen und Mittel, Lügendetektoren wären solche Mittel, welche die Denkfähigkeit oder die Willensfreiheit einer Person beeinträchtigen können, sind bei der Beweiserhebung untersagt. Und in Absatz 2 steht, solche Methoden sind auch dann unzulässig, wenn die betroffene Person ihrer Anwendung zustimmt.
Ganz genau. Und es gibt ja da auch gewisse Studien zu diesen Lügendetektorentests, die eben zeigen, dass diese Mittel nicht verlässlich sind, weil sie Leute oder Zeugen beeinflussen können und andere Faktoren irgendwie den Puls erhöhen oder die Hautspannung oder was da alles noch gemessen wird gleichzeitig oder Feuchtigkeit, Schweißaussonderung und dergleichen eben beeinflussen können und dass daraus eben nicht sicher darauf geschlossen werden kann, dass die Leute lügen. Es kann auch sein, dass sie nervös sind in der Einvernahme, weil sie in einer ungewohnten Situation sind.
Ja, also ich würde sogar sagen, in aller Regel sind die Leute nervös in einer solchen Situation.
Genau, da müsste man sonst bei der Strafverfolgungsbehörde schon Stammkunde sein, dass man sich eine gewisse Relaxedheit in der Einvernahme angewöhnt hat.
Und auch nicht so überzeugt bin ich von den positiven Seiten der KI. Ich bin eher ein bisschen skeptisch, was die Zukunft anbelangt. Vor allem, wenn wir nach China schauen, wo es sogar schon so weit ist, dass die Richter und Richterinnen schriftlich erklären müssen, wenn sie nicht mit dem Urteil einig gehen, das das System ihnen vorgeschlagen hat. Also das hat mich schon echt schockiert.
Auch fand ich interessant, dieser Aspekt der, ich glaube, man nennt das Regression zur Mitte, wenn AI-Tools eben eingesetzt werden, jetzt von Seiten des Richters oder der Richterin, um sich anzeigen zu lassen, in diesen oder ähnlich gelagerten Fällen haben Richterkolleginnen in so vielen Fällen so und so entschieden, dass man dann immer in die gleiche Kerbe schlägt, so dass man dann immer weiter das Tool wieder mit neuen Urteilen füttert, die das dann wieder bestätigen. Und so kommt man dann immer näher sozusagen in dieses Mittelfeld, wahrscheinlich statistisch gesehen in der Urteilsfindung. So oder so ähnlich musste das, glaube ich, funktionieren, wenn ich Sie richtig verstanden habe.
Ja, und es fragt sich dann halt eben auch, ob und wie sich das Recht dann allenfalls weiterentwickeln kann.
Genau, also es braucht Fantasie und keine AI-Tools, die nur bereits Geschriebenes wiedergeben.
Und vor allem den kritischen Umgang, denke ich, mit AI-Tools, die sicher auch einige Vorteile schon mit sich bringen, aber man muss eben kritisch bleiben.
Ja, sehr spannend. Nadine, dann müssen wir uns langsam verabschieden. Mit dem Hinweis natürlich noch, dass, wenn den Leuten diese Folge gefallen hat, können sie uns folgen, beispielsweise auf Apple Podcast oder Spotify. Da kann man uns auch Bewertungen dalassen, am besten natürlich sehr gute Bewertungen, darüber würden wir uns sehr freuen. Außerdem kann man uns Feedback geben auf eine E-Mail-Adresse. Wie lautet die, Nadine?
Ja, genau, die lautet fokus.strafrecht@jus.uzh.ch. Die findet man auch in den Shownotes.
Im Übrigen müssen wir noch unserer guten Seele danken, Wilma Rall fürs Produzieren und Johann Strauß dem Jüngeren fürs Komponieren der Waldmeister-Ouvertüre. In dem Sinne, bis zum nächsten Mal.
Auf Wiederhören.
Ade miteinander.